Hi, I'm Nick Gillespie with Reason TV, and today we're talking with Reason Senior Editor Damon Root about the three most interesting cases in this Supreme Court session. Damon, thanks for talking with us.
Thank you.
You just were at the oral arguments for a bizarre case in Florida. What's going on?
So this is a case called Koontz v. St. John River Water Management District. Essentially, it's a state regulatory agency. It tells this property owner he's got a small parcel of land he wants to commercially develop, but they say, we'll give you the building permits if you obey certain conditions. And the main point of dispute between them is that the agency said you've got to perform off-site improvements to public land. It's like 10 miles away, 50 acres of public land.
So I want to develop this part of land, and the state says, sure, go ahead, but then you got to fix up this other parcel of land. Does he own it?
No, it's public land.
Yeah.
And so he says, well, he refuses to do this. He sees this as extortion by the government. Right. Says, the takings clause of the Fifth Amendment says if you take my property for public use, you have to pay me just compensation. This is a public use. I shouldn't have to bear this burden. So this case makes it to the Supreme Court. There's also a second sort of related issue, and which was actually really was the big deal today, which is money. Is the government says you have to pay for these mitigations, these off-site improvements. Does that count as a taking under the takings clause? And Florida and the federal government said no, cash extractions, that's not a taking. And that was something that the majority of the court seemed to reject.
Yeah, and you were saying that it seems like an open and shut case to me, but what do I know? But the Supreme Court had looked pretty bad against the plaintiff in this.
Yeah, the property owner had a hard time before the court today, and one of the things that was a little surprising was that Justice Scalia, who's typically seen as someone who's conservative, he's in favor of property rights and so forth, he seemed pretty skeptical of aspects of the government's case, particularly the idea that any sort of taking occurred. Mm-hmm. His argument was if the permits were denied, therefore nothing was taken from you, it's not a taking. This court doesn't need to hear this case. And so if he sides with the liberal bloc on that, then they lose on that point.
Okay, next case has to do with blood tests or being accused of driving under the influence.
Yeah, this case out of Missouri versus McNeely. And this basically says, does the Fourth Amendment, which prevents the government from doing unreasonable searches and seizures, does the Fourth Amendment force the police to get a search warrant if they suspect you of drunk driving and they want to take blood out of you? The police argument, the government argument is that alcohol dissipates in the blood very quickly. There's what's called an exigent circumstance exception to the Fourth Amendment. Basically, the police need to act rapidly to get this, evidence of drunk driving out of you. They shouldn't need to go to a judge. And this case was argued last week, so we don't have the decision yet. But once again, this is an area where I think the government overreached, and it's probably not going to work.
But what is the status of if you reject a breathalyzer test? Aren't you in most places seen as presumptively guilty?
Yeah, that's right.
So why wouldn't a blood test be the same thing? If I say, hey, no blood test, then I'm just assumed to be guilty.
Well, really the issue here is that the blood test is more of an invasive procedure, and so should the police have to get a search warrant in order to perform that kind of sort of invasive procedure? So
what's your read? Do you think the Supreme Court will say no, they don't, or yes, the cops do need a search warrant?
I think they're going to say that the government's position, which is that there should never be a search warrant requirement in these cases, they're going to reject that. They're going to say in some cases we can understand why you might want to waive the requirement for a search warrant in specific cases, but as a general rule, no, we're not going to waive the Fourth Amendment.
So, and then the third case, or it's actually two cases, is about gay marriage. What's going on there?
Right. So this is sort of the big blockbuster at the end of the term, oral argument in March. There's two cases. One is Proposition 8 from California, which was a popular initiative that prevented the state from recognizing gay marriage, and then the other is a challenge to the Defense of Marriage Act, specifically Section 3 of that, which basically says the federal government does not have to recognize same-sex marriages that are legal. It's a legal same-sex marriage in Massachusetts, but the federal government's not going to recognize it. And so there's going to be one case for each of these issues.
So what's going on with Prop 8 is, where is the Supreme Court leaning on that?
Yeah, it's very hard to say where, especially on Prop 8, where they're going to lean. I mean, there's several questions. One is just who has standing to bring the lawsuit. What that means is that in California, the state of California has basically said we're not going to defend this law anymore. They've stopped defending it in court. So the backers of the initiative, they're now defending the law. And so the Supreme Court could say, well, you don't have standing. You're not the government. If the government's not going to defend this law, why should we listen to you, essentially? And so that could throw it back to a much earlier decision, which would potentially just limit the case just to the specific married couples who brought the suit, could limit it just to California. On the other hand, if the court was more ambitious, wanted to do something more historic, then we could see a right to gay marriage emerge from this case. Because what the issue is does the Equal Protection Clause of the 14th Amendment forbid the state from banning gay marriage? And so the court could say it does violate equal protection, and then there would be gay marriage would be constitutional.
And so then what about the Defense of Marriage Act? What's likely to happen there?
I think that's a situation where the law is more likely to be struck down. I think because there's some sort of federalism aspects to this. If it's legal in the state level, why should the federal government be sort of picking and choosing? So I think that we'll see the liberal bloc most likely joined by Kennedy. Justice Kennedy's got a record of he wrote Lawrence versus Texas, the big gay rights
But so
decision.
then we'll be in a kind of strange case where liberals are saying no, this is a states' right issue.
Potentially, depending on how it's worded.
But with Prop 8, I mean, they're basically saying, well, California as a state doesn't have the right to ban certain things.
That's right. I mean, there is this sort of tension. On the one hand, there should be a national standard for gay marriage. On the other hand, let the sort of states sort it out. I mean, these are issues in tension. And so we could actually see sort of the conservatives in majority on a Prop 8 case, limiting that to California, and then liberals in the majority and Defense of Marriage Act, protecting gay rights or recognizing equal protection on the federal level.
After the Obamacare decision, how has that changed the makeup of the court ideologically, or has it at all? Is there still a pretty solid conservative group and a pretty solid liberal group, or are things muddier now?
I don't think it's changed the makeup. I think that there's these two blocks. I mean, definitely one thing that emerged is that Justice Roberts is not someone you can count on to vote in a way that conservatives are always going to like in terms of sort of a policy outcome, and that he's potentially a swing vote in the way that Kennedy was. But then, one of my takes on Roberts all along has been this is a guy who's kind of an old school judicial conservative. He believes in judicial restraint and deference to Congress, and you see that in the Obamacare ruling. So this is actually the kind of thing that if you've been watching Roberts, it's not a total surprise that he votes to uphold this kind of law. But we're still going to see Roberts, siding with the conservatives. We've got an affirmative action case coming out of Texas, University of Texas. That decision's coming up. Roberts is likely to be voting against the affirmative action policy in that case. So he's still there's still this recognizable conservative bloc, but he's a little more in play.
All right. Well, Damon Root, senior editor at Reason.com and Reason Magazine. Thanks for talking to us.
Thank you.
For Reason TV, I'm Nick Gillespie.